Passport Bill, this is item 31, DA.18.08 of 2026.
Custody बताइए.
Custody since 22nd April 2026.
Charge sheet submitted.
Charge sheet submitted.
What is the stage?
Charge already framed, but no any witness.
Charge का frame हुआ.
Pardon?
Charge का frame हुआ.
Charge frame. 27th July 2026, and summon has been issued on 31st July 2026.
What is the next date? Next date. तारीख कब है?
तारीख 24 तारीख. 24 या 25 को.
Of this month. Of this month.
Next date.
Next week में है. Date.
ये 11 अगस्त को चार्ज फ्रेम हुआ.
11 अगस्त को चार्ज फ्रेम. ये तो बोल रहे हैं 27/7 को
चार्ज शीट है. चार्ज फ्रेम 27/7/2026 चार्ज फ्रेम के बाद 31st जुलाई 2026.
ऑनलाइन में क्या बता रहा?
11 अगस्त.
लेकिन चार्ज फ्रेम हो चुका है, इसमें तो कोई डाउट नहीं है ना.
जी.
क्या नाम है उनका?
कन्हाई बावली.
इनका 183 का स्टेटमेंट है विक्टिम का. देख लो
डायरी में वो आया है लॉर्डशिप. काउंटर में हम कनेक्ट करते हैं. डीएनए टेस्ट के लिए 25 मई 2026 पर सीजन के यहाँ ऑर्डर हुआ था. उसके बाद ये ब्लड सैंपल कलेक्ट कर लिया गया था जेल से विक्टिम पिटिशनर का, और 9/6/2000 परमिशन ग्रांटेड फॉर सेंड डीएनए टेस्ट. पैराग्राफ 90 ऑफ द केस है.
डीएनए टेस्ट अभी आया नहीं.
डीएनए टेस्ट मैंने इन द मीन टाइम एबॉर्शन हो गया. ये कहते हैं पैराग्राफ 101 में कहते हैं इलाज के दौरान गर्भपात हो गया. बातनी द्वारा अस्पताल और डॉक्टर का नाम नहीं बताया. डायरी का 101.
एनीवे डीएनए टेस्ट के लिए गया है तो टेस्ट रिपोर्ट तो आएगा ही. एबॉर्शन हो गया कब हो गया, इससे क्या लेना देना.
डीएनए टेस्ट के लिए तभी हुआ है
ना. क्या बोलना है आपके लिए?
सर ऐसा है कि ये बड़ी बहन का जेवर आया मेरे घर में.
प्रेम संबंध 6-7 महीने से चल रहा है.
संबंध नहीं था. उसने बोला कि हम शादी करेंगे.
नहीं ऐसा 183 स्टेटमेंट में बोली है कि जिससे मेरा प्रेम पिछले 6-7 महीने से चल रहा था. इस दौरान उसने शादी का वादा किया और रिलेशनशिप एस्टैब्लिश किया जिससे वो प्रेग्नेंट.
तो उसने शादी का झांसा दिया था कि हम तुम्ही से प्यार करते हैं, तुम्ही से शादी करेंगे, और यही कहा कि उसने रिलेशनशिप में और
लेकिन ऐसा स्टेटमेंट
सी इज
मेजर आल्सो 27 चार्ज फ्रेम हो ही चुका है. कुछ शादी ब्याह का स्कोप है. दीदी का देवर ही तो है.
तो हमने तो ये शादी कर ली है.
अच्छा आपकी शादी हो चुकी है.
हाँ शादी हो गई है.
एक सेकंड.
हाँ इनकी शादी हो.
आपकी शादी हो गई.
हाँ वो इलेक्शन 2 में लगाए हैं लॉर्डशिप. उसमें
heard the learned counsel appearing on behalf of the parties. The learned counsel for the petitioner submits that the petitioner is in custody since 22/4/2026 and charge has also been framed. To this, the learned counsel for the informant / victim has submitted that the next date for production of witness before the court is in the next week. The learned counsel At this, the learned counsel for the petitioner has also submitted that a sample has been sent for DNA test, but the report is still awaited. Counsel for the state has submitted that the statement of the victim recorded under section 183 BLSS be produced. After hearing the learned counsel for the, it is all clear, the counsel for the informant has opposed the prayer copy. After hearing the learned counsel for the parties, and upon going to the statement of the victim recorded under section 183 BLSS, she has declared her age as 27 years and has also stated that the petitioner is the brother-in-law of her sister. And there was love relationship between the two for 6 to 7 months. And in the meantime, the petitioner had promised marriage with her and established relationship with her, and consequently she became pregnant, and subsequently he refused to marry. The DNA report still awaited. Considering the statement of the victim recorded under section 183 BLSS, wherein she has stated that there was love relationship for last 6 to 7 months, and charge having already been framed, the petitioner is directed to be enlarged on bail. The petitioner shall not disturb the victim in any way.
Item 32,
हाँ?
इसमें 2 FIR हुआ था।
दोनों का बेल एक ही केस में फाइल किए क्या?
नहीं 2
FIR
FIR
से क्या
हुआ था
लेना?
इसमें। फर्स्ट FIR हुआ था।
आपको बेल लेने के बाद भी आपको बहस करना है, तो बस ज्यादा बहस करिएगा तो ऑर्डर अभी साइन नहीं हुआ है। इसको याद रखिए।
Item 38, DA.18.08.2026 of 2026.
बताइए क्या है आप?
rejected on matter 16/12/2025. हम लोग का एक नेट है 376 का केस कर दिया है और दोनों के बीच में लैंड डिस्प्यूट चल रहा है। कोई
नहीं, ये मेरिट में तो ऑलरेडी रिजेक्टेड है, इसलिए
हाँ,
मेरिट का तो बात ही मत करिए।
मारोड को
अब आपको क्या चाहिए खाली इतना बताइए।
हुजूर हम जेल कस्टडी में हुजूर
कस्टडी करता है ये कब से?
8/7/2025।
चार्ज तो आपका बना है 10/11/25 में।
माय लॉर्ड, बट माय लॉर्ड till now no any single prosecution witness। और दोनों के बीच में हुजूर अपना जमीन का विवाद चल रहा है, अपना एग्नेट्स है और केस कर दिए हैं। हम एकदम अपना लोग है, अपना फैमिली मेंबर लोग है और वही केस कर दी जमीन विवाद के चलते। हुजूर अगर कहेंगे तो हम सप्लीमेंट्री फाइल कर देंगे जो जमीन का केस चल रहा है। कोई मेडिकल भी सपोर्ट नहीं किया है, ओनली एलिगेशन लगा दिए कि बोल हमको अच्छा 5 दिन के बाद FIR होता है।
6 महीना का ऑब्जर्वेशन देते हैं, विटनेस नहीं आएगा तो आपको भेज देंगे।
3 महीना का 3 मंथ कर दिए।
डायरेक्ट एलिगेशन है, विटनेस नहीं आएगा इसका मतलब वो ऑस्ट्रेलिया होने वाला है।
8
ये नंबर डायरेक्ट एलिगेशन है, फैमिली मेंबर का डायरेक्ट एलिगेशन बहुत सीरियस होता है।
उसमें आफ्टर 5 डेज FIR लॉन्च हुआ।
इतना सा बात समझिए, फैमिली मेंबर का डायरेक्ट एलिगेशन इन केस ऑफ रेप इज वेरी सीरियस। आपको छोड़ देंगे तो सेम परिवार में जाके रहेंगे ना, कितना मुश्किल है विक्टिम के लिए, समझे? इसलिए थोड़ा रुकिए। आप विटनेस का ही नहीं प्रोड्यूस करते? डायरेक्शन तो हम देंगे, लेकिन आपको कौन सा, आपको तो लॉ में डायरेक्शन है। विटनेस ने प्रोड्यूस करके आप लोग क्या करते हैं पता है? बेल लेने में मदद। यही मतलब है ना इसका? ये भी एक एंगल है ना इसका? 6 महीने में ट्रायल खत्म करिए, समझ आ रही बात? BA number 7035 of 2026. Heard the learned counsels appearing on behalf of the parties. The learned counsel for the petition submits that the bail application of the petition was rejected earlier on 16/12/2025 in BA number 9505 of 2026, and he has renewed the prayer for bail primarily on account of custody. The petitioner is in custody since 8/7/25. The charge has been framed on 10/11/2025, but no witness has been examined so far. The impugned order is dated 5/5/26, which also reveals that in spite of the fact that the matter was fixed for evidence, but no witness has turned up. Learned counsel for the state has opposed a prayer for bail and has submitted that there is direct and specific allegation against the petitioner, and petitioner may not be enlarged on bail. He submits that appropriate steps will be taken so that the witnesses are produced before the court. This court is of the view that the bail application of the petition was rejected earlier on merits, and there is direct allegation, and therefore this court is not inclined to enlarge the petition on bail at this stage. The state is directed to produce the witnesses before the court. The counsel for the promptly produce the witnesses before the court. The counsel for the state is directed to communicate this order to the director of prosecution and to the SP of the concerned district. However, the petitioner may renew his prayer for bail after 6 months.
Item 39, BA 7378 of 2026.
Last order, action given to final report.
Yes, we counter ready. As per the direction of the novel court, matter was inquired from the concerned central jail below, Medinagar. And during inquiry, it has come that the petitioner, namely Deepak Mathur, and the accused Deepak Gurulia alias Manoj Gurulia, are the different persons.
Are they?
Yes. I have mentioned in paragraph
13.
11, 9, and
9.
13.
तो जो एंटीसीडेंट है वो किसके नाम से है?
इसी का नाम से दो केस बेल लगाए हैं।
किसके नाम से है?
दीपक
मतलब
महतो।
आपका क्या नाम है?
दीपक महतो।
दीपक महतो। और ये बुलबुलिया कौन है?
वो अक्यूज्ड है 2009 में।
2009 में अलग केस में।
अलग केस। इसको प्रोटेक्शन वारंट उठा लिया है।
जिस केस में ये बेल एक्चुअली प्रेयर कर रहे हैं, उसी केस में दीपक गुरुलिया मेन अक्यूज्ड।
ओ ये नहीं है?
ये
अगर ये सब नहीं हम लोग कराएं तो आप तो इनको जबरदस्ती जेल में रखनी है।
What has happened in this case? A petition was filed by the informant before the learned court. Okay. For production warrant.
And without any inquiry,
on
they
the
allowed.
basis of that, the petitioner was demanded in this case.
तो अब इनको रिलीज कराए कि नहीं? कौन किसको इनको रिलीज कराएगा? इनके ऊपर तो केस नहीं बनता है। बनता है?
नहीं बनता।
इसमें इनका कोई रोल नहीं। ये वो अक्यूज्ड ही नहीं है।
इस केस में अक्यूज्ड ही नहीं है।
नहीं है। ये सब इस केस में अक्यूज्ड नहीं है। Mistakenly he was demanded in the
by mistake.
Yes, ma'am. On the basis of the petition filed by the informant before the learned court. I can mention
कब से कस्टडी अभी आपका?
4 में कस्टडी है मैं।
पता है?
23/4/26
इस केस में रिमांड
23/4/26
I have mentioned in para 11 of the contract. स्टेट का कोई रोल ही नहीं है, प्रोसिक्यूशन का कोई रोल नहीं।
The learned counsel further, कोई earlier rejected भी है आपका?
नहीं।
तो ये यहाँ पे क्यों आ गया?
वहाँ 12 डेट हुआ
ये
उनको
केस मेरे पास क्यों है लिस्टेड? ये तो क्राइम अगेंस्ट वुमेन है क्या है?
या आपको 2009 की सैंपल पीएस 376 का है, इसी वजह आपके पास है।
अच्छा,
ये स्टेट का
पीएस केस क्या है ये?
चैनपुर केस केस नंबर 104/2009।
अच्छा, अच्छा। Heard the learned counsel appearing on behalf of the parties. The learned counsel for the petitioner submits that the petitioner has been falsely implicated in this case on account of mistaken identity. He further submits that FIR में भी alias name है।
एफआईआर में मनोज बुलबुलिया, दीपक बुलबुलिया, इसका नाम नहीं है।
दीपक महतो नहीं है।
अच्छा। He submits that in the FIR, the name of the accused is Deepak Bulbulia alias Manoj Bulbulia. But the name of the petitioner is Deepak Mehto. The learned counsel further submits that the case was registered in the year 2010, and after lapse of 16 years, the informant of the case filed an application dated 2/12/2025 alleging that Manoj Bulbulia alias Deepak Bulbulia was also known as Deepak Mehto. He submits that there is no statement of witness to this effect, nor any TIP has been conducted of the petitioner, nor there is any fingerprint comparison, no photograph or scientific report has been brought on record to connect the petitioner with the alleged offence. Deepak Kumar Mehto is son of Ram Balak Mehto, and he belongs to an entirely different family lineage. Who is the petitioner before this court? वो जो एक पुराना बेल एप्लीकेशन के बारे में जिक्र किया था, उसके बारे में भी पता किया है।
Yes, petitioner का sorry वो दीपक बुलबुलिया का वो बिल है। He was remanded in the year of 2009 in the present case.
The learned counsel for the state has filed a counter affidavit in this case, which is taken on record. She has referred to paragraph. नहीं, इसको तो कोट ही करना पड़ेगा ना, फिर कैसे होगा इनका, तो इनके काम आएगा ना आगे।
Yes, para 9 में दिया है।
Paragraph 8 to 13 of the counter affidavit, and has submitted that Deepak Bulbulia and Deepak Mehto are completely different persons. She has submitted that in the present case, Deepak Bulbulia is the accused and not Deepak Mehto. इसको कोट करेंगे ये पैराग्राफ।
One of the Deepak
After hearing the learned counsel for the parties and considering the counter affidavit of the state filed by Lalji, son of Ramphal Singh, posted as working as sub-inspector of police cum officer in charge of Jaipur Police Station, District Palamur. Even as per the state, the petitioner is not the same person as Deepak Gugulia, who is in fact the accused in the present case. This court is not in a position to pronounce anything further apart from what has been stated in the counter affidavit. However, in such circumstances, the petitioner is directed to be enlarged on. देखिए आपका बहुत बड़ा काम हो गया, नहीं तो आप बहुत परेशान हो।
वहाँ 12 डेट का रिपोर्ट जमा ही नहीं हुआ पीछे कुछ
And this is next.
From supplementary list for find solar atom 1, second appeal 118 of 2010.
आपको कुछ बोलना है, कलम लिखा तो सब बोलो।
विनीता शर्मा का
विनीता शर्मा ने क्लियर कर दिया,
क्लियर कर दिया।
सब क्लियर कर दिया है। पैरा नंबर कौन सा है?
137 में लास्ट है 137/4 इस पॉइंट को भी
हाँ, लिखिए
SSC
पहला कि पार्टी बनाना।
हाँ जी पार्टी बनाना दे दिस से पेज 90 पर
याद नहीं रहता है इतना किस केस में क्या डिसाइड हुआ था, थोड़ा थोड़ा प्रिंसिपल और लॉ ही दिमाग में रहता है।
तो इसमें सारा सबक कर दिया गया
तो ये तो पूरा डील किया गया कोपास्टर है कब से है एक एक पॉइंट को डील किया गया है फॉर सो फार द डॉटर इज कंसर्न
That's
इवन इफ की
para 137 of Vinita Sharma versus Rakesh Sharma reported in bracket 2020 bracket close 9 SCC page 1 has been referred, and during the course of argument it is not in dispute that a daughter in the family, when a suit has been filed seeking partition of co-pastory property, the seeking partition is a necessary part. तो उसको तो डिसाइड कर देंगे. Now it will go to the trial court, right? She will just file a written statement. If required, issues may be reframed and parties to proceed as per law. यही है. अब additional written statement वगैरह का कोई काम नहीं.
नहीं खाली इसी पर
ठीक है. जिसका एक का जो है जिन्होंने जो अपीयर नहीं हुए थे,
डिफेंडेंट नंबर 9
डिफेंड नंबर 13
डिफेंडेंट नंबर 13, उनका हम रीओपन नहीं करेंगे.
इसका
That I will not reopen. Considering the fact that the appellant number 2 is a necessary party in view of the section 6 of Hindu Succession Act as amended with effect from 9/9/2005, which happened during the pendency of the suit. Suit pending house.
सूट पेंडिंग
And by virtue of such provision, the daughter in the family has been given the status of co-pastor with respect to co-pastorly properties. The impugned order holding that the appellant number 2 was not a necessary party cannot be sustained in the eyes of law. The impugned order has been passed primarily referring to the stand taken by the appellant number 2 in the memo of appeal. But in view of the aforesaid legal status of appellant number 2, which has now been settled by the Honorable Supreme Court in the case of Vinita Sharma, the matter has to be remanded back The fact remains that no purpose will be served by remanding the matter to the appellate court, as now she has to be added as a party. अब कहाँ पे वहीं पे करेंगे party?
ट्रायल वन ट्रायल
As a party in the suit proceedings, and she is also required to file a written statement. She's also entitled for filing an opportunity to file written statement. सूट कब का है?
2003
Okay. सारे पार्टीज यहाँ पे अपीयर कर रहे हैं.
I am for the respondent number
Which respondent?
the Gopesh was
मेन
main
टेस्टिंग
plaintiff
Plaintiff. और
बाकी सब इन्हीं के भाई हैं
बाकी तो आप ही के भाई बंधु
हां भाई वो अपीयर कर
है ना, आप अपीयर कर जाएंगे.
हाँ.
ठीक. और ये जो मतजरी देवी है, क्या नाम है इनका?
जो लोग यहाँ अपीयर किया सब कर सकते हैं रिस्पोंडेंट में वन के बाद सारा
मतलब you will ensure that all the defendants in the suit appear before the court. Should I write that? ये तो नोटिस करना पड़ेगा कोर्ट को. रिमांड करने से नोटिस करना पड़ेगा.
notice will go, my lord, because in the original suit all the parties have not appeared. Only 1 to 8 and 10 and 11 they have appeared. 9 has not appeared.
तो जाएगा नोटिस फिर से.
Notice will require to.
Okay. The appellant being the Ram Sevak Sir and Usha Devi, and also the respondent number 1, Gopeshwar Sir, who are appearing before this court, are directed to appear before the learned court, the learned trial court on I'll give a date. The suit stands restored, and the plaintiff, उसके बाद क्या कोई पिटीशन फाइल करना पड़ेगा फॉर एडिशन ऑफ पार्टी में.
तो हजू का आदेश हो गया तो
अभी वहां पे जाके add हो
Okay.
जाएगा.
The counsel for the plaintiff undertakes to add Usha Devi as co-defendant in this suit. The needful will be done, and the other parties be also noticed by the learned court so that they may also come and participate in the case. That's all.
Right of WS, my lord, may indicate it is only for the applicant number 2.
Certainly, एक ही appealant number 2, बाकी नहीं. Right.
Because
So far
remand-
as
जी.
like so far as the appellant number 1 Ram Sevak Sah is concerned, there is a clear finding by the learned first appellate court that he did not appear and participate in spite of service of notice. The finding is sustained, and therefore there is no question of grant of any opportunity to appellant number 1 to file written statement. That's all. तो डेट देंगे हम 2-3 महीने के बाद का. बाकी हम कल लिखा दिए थे. थोड़ा तो लिखना पड़ता है, बैकग्राउंड तो पूरा ही लिखना पड़ता है. फर्स्ट अपील है, सेकंड अपील है, तो कुछ लिखना पड़ेगा. ये सारा नहीं है, ये कुछ और केस है. Madam, you can go and complete your work. ये सेकंड अपील में, ये सेकंड अपील का है. ये विनीता शर्मा का जजमेंट है. अब ये आपका ड्राफ्ट है. ये दूसरे केस के लिए है. The impugned order is this case is accordingly disposed of in the substance. Since the suit is of the year 2003, the learned court is directed to take appropriate steps for expeditious disposal of the suit. Parties to court.
unnecessary adjournment will not be given to any
Parties to cooperate.
Item Q, first appeal 154 of 2023.
Nice.
In this case, Lordship, we are saying that in there are sufficient material record, so the matter may not be remanded to the learned trial court.
You happy?
But so far as Lordship so proposes to remand the matter.
No, I don't propose. I am always inclined to decide the case on merits, even if it is first time. If you say that there is sufficient material to decide the case on merits, I will decide.
So far as the issue which is related to the self-acquired property or whether it is ancestral property.
There is no dispute on that. It is not a ancestral
That is an
property.
admitted proposition.
It is
that
nobody's
the
case that it is
self-acquired
an-
property of the mother.
When you argue, you have to argue the case then. What do you say? You also want a decision from here, I say.
My most humble submission from what had transpired yesterday was, even if this issue, my lords, even if it is accepted that it is a self-acquired property, even still, my lords, a case, whether it is a case of partial partition or not, and whether
No,
they
you
fall
see,
within the exemptions
just a
or not.
moment.
Yes.
The point, whether it is whether a partial partition would lie or not.
No.
The property which is self-acquired property and the property which is co-pastoral property are two different properties altogether. Even when the property which is co-pastoral property is subject matter of partition, the self-acquired property will not be included in it. That is bound to be excluded. Yes.
Only reason why I'm saying so much is that when the plaintiff was put to question as to what has happened with what had happened with respect to the other properties, without ascertaining on this point, there was no evidence because no issues were framed.
No, you see, we have to see the plain and the written statement.
I go down to that. I go down to that.
And if there is no semblance of this property being a part of co-pastoral property, is it your case that it is a part of co-pastoral property?
From what has been stated in the written statement, it seems that there was a bundle of properties apart from this property, which would also have been subjected to partition. Because there is a question which was posed to me also, to which I have very bluntly replied that I will not let this person in the property unless the other properties which are there, that is also partitioned and I get a right in that. So in light of just one small submission with respect to this, that when the plaintiff was put to question with respect to that, he has said that all the other properties have already been partitioned except for this property. So in light of that humble submission, and I came across a judgment of 1954. Apparently, that was an unreported, which says that if there is a property, if a partial partition has taken place previously, then in that case it will be deemed that all the properties subsequently have also been partitioned. I could not go to the exact, but the complete judgment. So in light of that, if an issue has been, if that has cropped up, then perhaps it would be better if it is adjudicated. I had
You
shared
see, the trial court has only dismissed the suit on the sole ground that he has not been able to prove the title.
yes.
Now, I think there is no dispute on this, that in a partition suit, title dispute cannot be decided unless it is incidentally required to be decided. And the title dispute is raised and it is raised between the parties.
I have also not disputed that fact that the property was purchased in the name of large.
That's it. There is no dispute on that. So this approach of the trial court is incorrect. And the trial court has not gone into the merits of the case. Whatever be the merits, he has not gone into that. Now, a plea of objection by way of partial partition was taken in the written statement. No issue on partial partition has been framed. And therefore, since the point was raised that issue was to be framed and decided. So if we frame an issue regarding partial partition, then under such circumstances, the submission of both the parties is to be recorded by this court. Otherwise, it will be an indication as if it is subjective to partial partition. I will just record that the question of this, who is for that lady? What was the lady?
Lordships, I'm for the sons and the daughters of the late Lalkri Devi.
Okay.
And daughter-in-law is represented by my friends.
Okay.
She was the defendant, and here she is the respondent.
So I will just record that the plea of partial partition has been raised in the written statement, and the point was required to be decided.
So in that case, Order 41/25 provides that the Lordship may fix any issue or propose any issue to be fixed in the matter, and matter may be remanded to the trial court only to that extent for taking additional evidence, so as that issue is concerned. Order
तो यहाँ नहीं जान छोड़ेंगे क्या? मेरा ऐसा तो कोई पिटीशन कहाँ फाइल की है?
तो file Order 41/25 के Lordship may kindly see.
The case has not even been decided on merits. कुछ भी नहीं decide किया ना. Had the case been decided on merits, there was no problem about it. But he has not decided anything.
I should fairly submit that apart from issue number 3 and 4, all the other issues that has been decided, adjudicated, if I may so use the word, on the ground of this fact only that they did not prove that.
Even Lordship,
Tightly
number 3 and
is-
4 also has not been decided that there is unity of position. Their parties are also saying that there was unity of position. The parties used to decide together. Then also the trial court has observed that there is no unity of position and title.
Because they have the issue.
Because you are failing to
Failed to
prove the
prove the
title.
title.
The honorable, the learned court pillars that has the learned trial court pillars, it has not returned a finding that there was no unity of it. It has recorded a finding that there is no
Since
requirement
the
to
title-
go into the unity into the question of unity of title because the title has not been as per subject to correction from my learned.
I will just record that during the course of arguments, one of you have stated that the question of partial partition may not arise because this property is the self-acquired property. But still, this finding has also not been done.
This finding, that is what I was saying, that this finding has also not.
The court has not gone into this.
So Lordship, no issue was framed in this.
So some
Yes,
evidence
sir.
was laid on the point whether.
Now, I think there is no dispute with respect to the fact that there can be a partition with respect to self-acquired property, irrespective of the fact ancestral property has been partitioned off. Isn't it? If a person has this, आप इसको ना अपने family में देखते तब समझ आएगा, right? There are 4 persons, right? Uncles, everybody, and there has never been a formal partition with respect amongst them. Now there is a 3rd generation. One of the uncles has expired, and he has self-acquired properties. 3rd generation is not bothered about the ancestral property. Maybe that it is not much, or maybe it is not possible to get it partitioned and take a recovery. Maybe they are not interested. Then the self-acquired property of their father can certainly be subject to partition. And plea of partial partition will not come in the way. And if we take it in a reverse order, in a suit for partition covering co-pastory property, the self-acquired property stands excluded. They are not included in the schedule of property. If a parties agree that yes, this is a set, suppose there is a property which a person has, he is working somewhere, he has purchased his property by taking loan, and he has paid the entire money from his salary account, right? Then certainly nobody would like to include that property in a suit seeking partition of co-pastory property.
My uncle acquires a property out of his own independent
Yes.
income. It will be partitioned amongst his own sons.
Amongst
It
his
will
own
not be
sons.
partitioned with me.
Not at all.
But
So
my grandfather's property, I will.
certainly. When it comes to the property of the grandfather, then only there is a question of any kind of partition.
one small submission subject to correction. When the plaintiff was put to query, what has happened with the other properties, etc., he said he submits that there was an oral partition. But once the property was subjected to oral partition and it is devolved upon the concerned persons. So as to say.
Did he say that by virtue of that oral partition, this property devolved upon any of the
This
parties?
property is
not this property, but the other property.
Might have been.
Once that has happened, once the property has been partitioned, that has been accepted, so as to say, then that would also acquire the color of a self-acquired property.
And then that property should also have been included
In this
in the
in
partition.
the partition. If it was partitioned amongst the father of my father-in-law and their
But
father.
that's right, I get it. Is there any plea taken in the written statement
No, my lords, that
that there was a previous partition?
there's no plea as such, and lords, please.
This plea has come up only in the written statement regarding this property.
But there is no plea of previous partition in the.
There's no plea of previous partition in the written.
But the plaintiff is saying, no,
The plaintiff
that
may
there
not
was
be
a
on
previous partition.
cross-examination.
During
He's
his
saying, but
cross-examination.
he's also not aware about the partition. He says that he's not aware about the partition, so that partition is also not proved by as to whether that partition has ever taken place. No mention of any year or any property details have been mentioned. He only
Just
says that
You see, the question of these things would have come to surface only when an issue was framed.
It's true.
Unless an issue is framed, who will lead evidence on these issues? It requires evidence. Whatever be it, it requires evidence. Therefore, we
Yes, as that fallen from yesterday from your ladyship side, that partial partition cannot be so simple. You will have to look into the nuances.
It has a
Something
lot
like
of
that.
nuances.
Yes, something like
Partial
that.
partition
there
has
are
a lot of
exceptions
nuances.
of this where my lords, the property is not available for partition, that particular property, or where lordship it is outside.
People also deserve their right.
the-
They give up their right.
or it
All
is in
these
possession
things
of
are
some
there.
stranger, so that property
Somebody
cannot
may be only interested in the partition of the house by saying that we are not bothered what is lying there in a village. They might not be. Maybe that you see, these are social realities. Maybe in the village his family members are deciding he doesn't want to disturb them. Maybe in the village his family members are cultivating and giving him some proceeds from the
Or it is in-
cultivation.
It is in control of a third party. Nobody
party.
wants to
It
take
could
a.
be. It could be in control of a third party.
Nobody wants to take the burden of getting.
Yes, he evicted from the property. And once the property is in possession of third party, it becomes all the more difficult to partition it and get the recovery of that
That is the
property.
case also in the instant matter, because I spoke to the Millers, the client, they says that there is some property, ancestral property in their house, but that is being
Hardly
cultivated by the uncles and
Nobody
their
wants to
relatives.
disturb family
Now
members
millers
like
in
that.
this. But now
देखिए,
subject to correction.
everything you will appreciate in a family dispute when you see your own family. It is for everybody. Everybody has lot of ideas about joint family when it comes to their family.
I still stay in a joint family.
And that's very good.
But I was only going to say that the Lordship may kindly see order 41 to 25 for a moment.
No, you have not filed any petition.
But even without petition, Lordship may pass the
You
order.
see, the trial court has actually not.
Because
decided
take
it.
Millers, some more time Millers in disposal of this school. Because of only one issue is to be framed by the learned trial board. If the Lordship may so just frame that issue and send the matter for additional evidence, the Lordship will be the hearing may be done in the expedited manner. Only that issue is to be framed and that issue is to be decided. So far as whether the partial partition can be allowed in these. Apart from that, there are evidences and there are readings to the effect that it is a joint family property, not existing property, self-acquired by the mother. They are also not disputing it.
Nice, like, what do you want? You want the additional issue to be framed and sent? Will you be happy with that?
No, my most humble submission in this respect would be that if that issue, one way or the other, it is decided in that way, but one way or the other, but it would affect the entire outcome.
No, that certainly it will. Then that issue has to be seen with other materials on record.
In that case, but there is no. My most humble submission is it would not be feasible, but would not be whether it would be
Your Lordship,
judicious,
kindly,
my lords, to keep it
have a look
pending
at
here
the
and then
order.
remand it back to the.
Because only one issue
trial
is not
court, my lords, that would-
framed by the learned trial court, and that is which is to be framed.
Otherwise, my lord, your ladyship will have has power under Rule 23A also.
Order 40.
41 Rule 25. Where the appellate court may frame issues and refer them for trial to the court whose degree appeal from. Where the court from whose degree the appeal is preferred has omitted to frame or try any issue or to determine any question of fact which appears to the trial appellate court essential to the right decision of the suit upon merits. The appellate court may, if necessary, frame issues and refer the same for trial to the court from whose degree the appeal is preferred, and in such case shall direct such court to take additional evidence required, and such court shall proceed to try such issue and shall return the evidence to the appellate court together with its finding thereof, and the reason therefrom within such time as may be fixed by the appellate court or to be extended from time. That much your lordship may kindly pass the order, because only one issue is to be framed, and to that effect evidence can be read by both the parties.
Was also considered Rule 23A, my lord.
Yes.
Where the court from whose degree an appeal is preferred has disposed of the case otherwise than on a preliminary point, and the degree is reversed on appeal and a retrial is considered necessary. The appellate court shall have the same powers as under Rule 23.
It means what? It means that I can appreciate everything.
But
Under Rule 23, I have the same power as an
Rule
appellate court.
23 may remand it back for to be readmitted under the original number and then thereafter to be tried.
That will only prolong the trial, because only one issue is to be framed, and your order 41 Rule 25 does give power to this honorable court or to the appellate court to frame any issue and to send that. to the
See, the
learned trial.
point here is that the entire contours of the judgment impugned is absolutely erroneous. He has not appreciated anything apart from he has entered into the issue of title without appreciating.
But so far as the evidences or materials are concerned, it is available on record, which will my lords negate the finding of the learned trial. So far as those issues are concerned, my lords, for partial partition, your lordship may my lord send the matter to the learned trial court for giving its finding. Other issues, the learned trial court has rightly normally has decided the issue. And those evidences, those pleadings are also there
For example,
with
my lord,
respect to the ancestral or joint family property or unity of title or possession of the suit.
again with respect to unity of title per se, the learned court has not returned any finding. It has escaped the issue altogether.
There is evidence on record which says both the parties have said that they used to reside together.
That may be, but again, that has not
Evidence
been
is there on
appreciated.
record. The lordship may decide that issue in the right manner by considering the evidence on record. But so far as this issue is concerned, whether partial partition can be allowed in the instant matter, to that extent, the lordship may frame the issue and send the matter to the learned trial court to record its finding after considering
You
this.
see, the issues were framed. Parties have laid evidence on them. Now, whether those evidences were rightly appreciated, wrongly appreciated, can certainly be considered by the appellate court.
Of course, yes.
There is no doubt on that. Now, one of the important issue which arose out of plaint and written statement of the parties was regarding partial partition. That issue was never framed. So, under such circumstances, the court has the power to frame that additional issue and remit the matter to the court for recording evidence on that and also giving a finding on that. They'll give a finding also, return a finding on that. And then whatever be the evidences collected and the findings recorded, It will come back to the court. And then so far as other issues which are already decided in whatever manner it is, those materials and the issues can be considered by this court.
That I would on this for your leadership to consider was whether keeping it pending would be.
Only to say pending तो नहीं रहेगा, हम तो अभी जिंदा हैं, बेंच मेरा है. Pending का pending नहीं रहेगा, अभी तो मेरा बेंच अभी बताइए आप कितना दिन में आप इशू को करके ले आएंगे, इसी साल डिसाइड हो जाएगा. तो अगर बस आपके कोऑपरेशन का चिंता है और हम लोग को कोई चीज का चिंता नहीं.
हम कोऑपरेट करेंगे.
आप कोऑपरेट करेंगे.
Because the plea of partial partition they have raised in the written statement, so they will have to prove that the partition of the other properties has taken place. And
वापस इशू फ्रेम होने के बाद फिर होगा तो पहले पीडब्ल्यू आएंगे फिर डीडब्ल्यू आएंगे.
इशू जब फ्रेम होगा तो पहले तो पीडब्ल्यू ही आएंगे,
PW
डीडब्ल्यू तो बाद में आएंगे. तो आपको जो अपना एविडेंस देना है आप
don't fix any time frame. Examine the evidence.
कर लेते हैं. बहुत ज्यादा ना पता है
चलिए.
रिमांड, अगर मान लीजिए ऐसे रिमांड कर देंगे ना तो पार्टी का अगला जनरेशन पहुंच जाएगा,
2017 से चल
अगला जनरेशन पहुंच जाएगा. इट विल बी वेरी हार्श ऑन द पार्टीज फॉर द for the error of the
They are
court. We
fighting for their
cannot
own property matters. They will get the property in their respective shares. They purchase by the father of the or mother of the defendant.
by fixing the timeline of leadership to also consider that
आप जो टाइम बोलेंगे उतना time.
October November the learned trial court might be on.
they will file application for extension of time. हमारे यहाँ extension के लिए आएगा ना भाई, तब सोचेंगे क्या करना है.
I'm just bringing it to your leadership notice.
होली दिवाली कहाँ मनाता है कोर्ट, आप लोग मनाइए. देखिए फर्स्ट अपील नंबर 154 of 2023. Heard the learned counsels appearing on behalf of the parties. बिल्कुल, आपको तो कहीं जाना है, किसी और को. हाँ? He's going on leave. बहुत चीज सोचना पड़ता है, टाइपिंग में डिले हो जाएगा. जजमेंट ही हिंदी में लिखते हैं, आप क्या बताएं. इश्यूज कहीं इंग्लिश में फ्रेम हुआ है क्या?
Issues English में है. That is in the trial court record when we pass on the
हाँ. इसी का ही कॉपी होगा ना.
इसका ही copy. Was framed on 17/1.
वही धनबाद वाला केस चल रहा है, उसको तो हम सोचे उसको हम रिमाइंड करेंगे ही. अब आपने मतलब क्या बताएं, बहुत सारे ऐसे कंटेस्टेड केस है, अगर रिमाइंड कर दिए ना तो 2-3 जनरेशन तक डिसाइड नहीं.
That is English for the issue. The top notes 26 is written.
ये proposed issue यही है क्या? Whether the suit was filed is maintainable. How many issues were
Just
proposed?
before that, notes 27 perhaps is the proposed issue,
And
26 notes is the issue which are being framed by.
6.
The top right corner.
Okay. These are the issues which were framed, right? कोई substitution तो नहीं हुआ है.
Please.
Everybody is alive.
Everybody is alive.
Sorry.
वकालतनामा सबका फाइल यहाँ
ठीक. I'm just waiting for this to move. नॉन जॉइंटर वगैरह में भी कोई फाइंडिंग नहीं है इसमें.
नहीं. बेसिकली सारे इशू का एक ही है कि ये नॉट
थ्री और फोर पहले डिसाइड करके फिर उसके बाद
but they have raised the issue of non-joiner parties only on the ground that the other properties, those have not been included in the suit properties in there. Otherwise, they are not disputing that for this particular property, there are other parties as well.
बैक फॉर पार्शियल पार्टीशन कहाँ है? All the properties have not been included.
The written statement mentioned at para 7 of it.
Yes.
This is bad for non-joiner BCD parties. Then they have mentioned about the details of land situated in there. They have also mentioned that the branch of the successors and the recorded tenants they are not being partitioned.
that the above lands have not been partitioned by meets and bounds between them.
Heard the learned counsel's opinion on behalf of the parties. This appeal has been filed against the judgment dated 23/3/2023, within bracket decree signed on 29/3/23, passed by learned civil judge within bracket senior division, that is post Roman 12 ranking, in original suit number 510 of 2017. Whereby the suit filed by the plaintiffs has been dismissed. The suit was filed for the following relief. Page 48 of memo of appeal number. The learned counsel for the appellant has submitted that the trial court framed the following issues for consideration. ये LCR का page number 26 number. He submits that the learned trial court had gone into the question of title in the partition suit, although there was no dispute in connection with title of the property. The suit was essentially for partition of the property which was said to have been purchased by late Dinanath Singh in the name of his wife Srimati Lalpari Devi by way of registered sale. He has also submitted that Dinanath Singh and his wife were the common ancestors of all the parties to the suit, and acquisition of property by registered sale was not in dispute. Correct? The learned counsel submits that once there was no dispute in connection with title of the property and the parties claimed to be in possession, there was no occasion for the learned trial court to enter into title dispute, enter into title with respect to the scheduled property. He submits that the suit has been dismissed primarily on the same ground. He submits that even no issue was framed with respect to title of the property, and the issues were primarily related to partition. At this stage, the learned counsel for the respondents has submitted that the defendants had raised a plea that there were numerous other properties and the suit was bad for non-joinder of necessary parties, And the reading of the written statement would reveal that an objection was sought to be raised on the point of partial partition inasmuch as the other properties of the family was not included. Of the details of the property were also mentioned, and the documents in connection with some of those properties were also exhibited. Right? You exhibited those savings. He submits that the in view of the averments made in the written statement, one of the core issue which was required to be framed and decided was as to whether, in the light of averments in the written statement, in the light of averments, a case, as to whether the suit was bad for having been filed for partial partition. Okay? He has also submitted that the issue regarding partial partition having not been framed by the learned court, the issue is required to be framed and decided. To this, the learned counsel for the appellant has referred to Order 41 Rule 25 of CPC and has submitted that so far as the other issues which were framed, the evidences are on record, which can be appreciated by this court in first appeal. And so far as the issue regarding partial partition is concerned, the same can be framed by this court, and the matter be referred to the learned trial court for recording a finding, for taking evidence on this issue and return a finding in that respect. After hearing the learned counsel for the parties and considering the fact that the written statement revealed that an objection has been raised for non-inclusion of other properties as mentioned in the written statement. And essentially the objection is with relation to partial partition. The learned court framed an issue regarding non-joinder or misjoinder of necessary parties, but no issue was framed with respect to partial partition. In such circumstances, this court is of the view that the following issue was required to be framed by the court, and accordingly, the issue is hereby framed at first appellate stage. Whether the suit was bad ये दोनों बना दें एक ही खाली partial partition
That is not in dispute. That
whether the suit whether the suit was bad for having been filed for partial partition. the issue, the aforesaid issue so framed by this court will certainly require evidence, and accordingly the trial court is directed to record evidence on this additional issue framed by this court and return a finding to this effect. The parties are directed to appear before the learned trial court. I'll just give a date.
Yes.
The needful be done by the learned trial court within a period of 2 months from the date of appearance of the parties. हो जाएगा 2 महीना में? ज़्यादा चाहिए? 3 months. Post this case on, I'll just give a date for posting. Okay.
Instead of running trial court, she may specify the court. So that
Trial court, I'll name the court. यहाँ पे तो होगा ना?
the designation.
Learned civil judge, senior division, Roman 12 Ranchi. जो भी हो, जो भी हो. This partial partition has lot of nuances. So there are conflicting judgments also. Some says that it can be done.
Yes.
Others says that it cannot be done. Some says that it can be segregated and left out.
Basically, one of the views is the jurisdiction. If the court cannot exercise jurisdiction of the property, what do you not? I also tried to search out. There is no concrete judgment.
There is no concrete
So I
judgment.
would take that it is usually not permissible. Exceptions case.
But at the same time, if the partition is for co-pastoral property, then personal properties are excluded. That is not included in co-pastoral property. So if there is a partition for self-acquired property,
Right.
then co-pastoral property will not come into
Correct.
there. And with a further writer that if co-pastoral property has already been partitioned, then that has to be included, because then it has to be treated as a self-acquired
Yes.
property and partitioned among the legal units.
Because the only because I'll just give an example of this case. Why you cannot seek partition of the ancestral properties, but the parties will be different.
Yeah.
According to my client, that those properties are still joined. There is no partition.
That's
Partition
right.
not. So how can I now seek partition for ourselves?
That's
So all these questions will be decided.
yes.
We'll
So
see.
these aspects of the matter will be considered in the first appeal,
Yes.
because I can see that maybe that the court may not be able to enter into these
Whatever.
kind of nuances, unless of course you
No, settlement.
help the court to do it.
Ultimately, you're right in sending the matter back for at least on this issue, return a finding and then come.
And then we'll decide. But the court has entered into tightly dispute.
No, that was not.
That is absolutely not.
That is absolutely.
That cannot be done in partition suit, tightly suit.
In fact, the law is that in a partition suit, the defendant is also a plaintiff. They can also bring in the.
Yes,
Everybody is a plaintiff.
See, in a partition suit, a person is in possession of the property without a title.
Correct.
Suppose he is living in a house, does not have a title. Still, he can go for a partition.
Yes, that concept of keeping the room belongs towards that perhaps is not necessary.
That's right. Anyways, let the findings come and then. No disposal नहीं है. We'll just give a date for return of finding.
Item 3, WPS 7008 of 2023.
ये क्या है? गोपीनाथ महिला महाविद्यालय. आप हैं इसमें? Who is there in this case? क्या हुआ? आपने एफिडेविट फाइल कर दिया?
I find this a little bit bringing on because all.
This एफिडेविट मतलब कहाँ है एफिडेविट आपका? You have filed it?
Yesterday we had.
लगाओ.
इसमें यूनिवर्सिटी की तरफ से इसमें R1 का रिस्पांस फाइल करने की कंप्लेंट था। सरकार जो भी है उसको भी कुछ निकाल देना होगा।
This is my only prayer. I filed everything with hyper last order.
आपका सोर्सेज ऑफ इनकम क्या क्या है?
मेरा सोर्स ऑफ इनकम हमेशा डेफिनेशन होता है 2023 तक हम फीस देते थे 22 तक 50 रुपये स्टूडेंट को और 12 तक 50 रुपये था, अभी 100 रुपये और 23 तक फीस भी नहीं मिलते हैं। लड़के लोग से फीस हम लेना बंद कर दिए। ग्राम से रेट मिलता है, रेट मिलता है और जमीन का कागज कुछ जॉनर के नाम से है और कुछ मेरे नाम से है और जितना पैसा जमा किए वो है इंक्वायरी यूनिवर्सिटी का रिस्पॉन्सिबिलिटी आया मुझे लीडरशिप commitment me also for a week I am not also week.
कितने टीचर्स हैं आपके? How many teachers are there? ये यूनियन ऑफ इंडिया जो है ना कॉम्प्रोमाइज नहीं करता, लड़ेगा पूरी तरह से। हाँ, ये एजुकेशनल इंस्टीट्यूशन है, क्यों उसके पीछे पड़ेंगे? और लोग नहीं मिलेंगे आप लोग को?
डिफॉल्टिंग पार्टी
डिफॉल्टिंग? अब एजुकेशनल इंस्टीट्यूशन झारखंड में तो डिफॉल्टिंग हो ही जाएगा ना,
हमें फीस नहीं
ये
लगा
तो पढ़ाई लिखाई कुछ होता नहीं।
filed a supplementary regarding the payment which they have made.
they say only that I have paid only
With
4
the 15 lakhs they have paid after the order of is 1 crore 35 lakhs.
65 lakhs I have paid. I have annexed
1
documents.
1 crore 25 lakhs is due. RRC has been issued against them. I have filed these details in a supplementary account.
They have deducted from grants in aid जब हम grant date से TPF काटे भी नहीं, not a single time. और एक बार काटे फिर चिट्ठी आ गया 22 में 21 में काटे एडिशन चिट्ठी आ गया, चिट्ठी का रिप्लाई मांगा you don't do this because other universities are not doing
तो
this.
दूसरे यूनिवर्सिटी को भी नोटिस कर दिए ना,
नहीं किसी को नहीं.
बंद करा दीजिए सब।
This is the only women's college in the entire area. We don't charge much. अब तो फीस भी नहीं लगता है फीस आप given each and every
स्टेट गवर्नमेंट टेक ओवर कर ले तो आपको क्या तकलीफ?
हम इंस्ट्रक्शन लेते हैं कुछ नहीं बात लीडरशिप का तो बहुत बढ़िया पास ये सजेशन है आई विल लेट यू आस्क माय क्लाइंट
टेक ओवर कर ले, आपको कुछ नाम आप दे दे कॉलेज में और यही ना चाहिए कोई मैनेजिंग कमेटी।
मैनेजिंग कमेटी स्टेट गवर्नमेंट का बनाया मेरा नहीं है, यूनिवर्सिटी का बना के साथ लास्ट पेज है मैं पेज नंबर परीक्षा 10 पेज 323 लास्ट पेज में लीडरशिप का है पेज 323 लास्ट पेज this notification by Ilama Kadamar is to leadership got it. Everything is considered principal of the current teacher representative, university representative, and officer of the state government posted in district will not be the rank of SDM. Donor member, one member noted by the VC, the member of the parliament of the state is one education donor cooperated by the G.
Donor member, so you are the donor member. कौन
No,
आपका
donor
कॉलेज
is-
ही है? Who is the donor?
I am not the donor member. One ex-MLA is the donor member. I am not the donor member. Everything is being done by university. I am just.
आपके कौन है ऑफिसर?
Shant Kumar was the assistant in charge.
उनसे नहीं निपटेगा। आप हमको ये बताइए, देखिए इनका कहानी कभी खत्म नहीं है, कवरेज में ये है, पुराना ड्यूज चलते रहेगा, आपका इंटरेस्ट चलते रहेगा और इनका ड्यूज कभी खत्म नहीं होगा, नहीं होगा ना? लेट अस टेक इट, है ना? दे विल ऑलवेज रिमेन अ डिफॉल्ट। कुछ वन टाइम पेमेंट करके कुछ स्कीम है आपका, तो कुछ तो करिए ना, ऐसे तो ये इंस्टीट्यूट बिल्कुल खत्म हो जाएगा। और आपको मारना ही है तो एक बार में मार दीजिए।
Each and every report I have brought.
मारना नहीं है ना, तो एक कॉलेज है, इसको आप सोचिए कि इसको कैसे, मतलब think of it, it is for the benefit of the entire area.
Only municipal in the entire.
I will ask about the one-time settlement.
इंटरेस्ट हटा के वन टाइम सेटलमेंट करिएगा तो सेटल हो जाएगा। इंटरेस्ट हटाइएगा ना तो आपका मेजर लायबिलिटी खत्म हो जाएगा इनका।
whether they can deduct from the grants in aid, this should also be clearly counter affiliated by university and both.
यूनिवर्सिटी ने तो फाइल ही नहीं किया, आपने तो चिट्ठी लिख दिया कि ग्रांट इन एड से डिडक्शन नहीं हो सकता।
शायद कोई मुश्किल नहीं कर रहा है, हम मेरे शुरुआत में ये चिट्ठी आ गई।
आपका एफिडेविट कहाँ है?
1 week का टाइम चाहिए।
1 week का टाइम में आपका एफिडेविट आ जाएगा। एफिडेविट किसका फाइल करिए? रजिस्ट्रार।
यूनिवर्सिटी से।
और स्टेट कौन है? स्टेट का कौन? They can deduct from grant in aid.
They are silent on this. They are silent.
Yes, can they deduct from grant in aid according to you? क्या instruction आपको? Can they deduct amount from the grant in aid? You see, there are two parts. One is deduction from the salary, other is contribution by the employer. Right? Salary से तो deduction समझ आता है. Right? What about the contribution of the employer? वो granted aid से permissible होगा?
Universities counter necessary. They have to. Others universities are not contributing through grants in aid.
क्या आपको assign हो गया ये matter?
Leadership can only handle this.
नहीं ऐसा कुछ नहीं।
मैंने पूरे एरिया का only लेडी पड़ेगा 50 रुपया 100 रुपया एक डॉक्यूमेंट है पर leadership डायरेक्टर एक डॉक्यूमेंट लेता है everything from 2012 till 2025 each and every document land total income total payment everything is documented।
हम एक्सेप्शन ले लेते हैं उसका लेकिन हम जो समझ रहे हैं ग्रांट से डिडक्ट नहीं,
ग्रांट से डिडक्ट नहीं होगा, इनके पास पैसा नहीं है तो कहाँ से देंगे?
टीचर गवर्नमेंट बड़ी रखे टीचर ही रखे हुए हैं, अपना इंटरनल सोचते हैं, फीस लेते हैं लड़के से, तो जमा करना है इनको नहीं फीस में।
और पूरा का पूरा कैलकुलेशन ग्रांट इन एड में ही है,
फीस तो मिल ही नहीं रहा है इनको, टीचर रखे हुए हैं और ग्रांट इन एड से टीचर को फीस दे रहे हैं, मतलब सैलरी दे रहे हैं, कहाँ से आएगा इनके पास पैसा? From where will they get the money? You want closure of this institution? अब ग्रांट इन एड क्यों देते हैं? इसको टेक ओवर कर लीजिए। That's right. Government can always take over institutes, नहीं?
हमेशा होता है।
इसमें इंस्ट्रक्शन ले लेते हैं, इसमें से रिजेक्ट नहीं।
The learned counsel for the university prays for some more time to comply the last order. A supplementary affidavit filed by the petitioner has been placed on record. The learned counsel for EPF as well as the learned counsel for the EPF is also directed to see the instructions in this case as to whether any one-time settlement is available to resolve the issue. The fact remains that the petitioner happens to be the only girls' college in the entire area, and the liability on account of EPF is accumulating day by day, and there are arrears with respect to EPF. It appears that the institute is primarily dependent upon the granting aid from the government and have not generated much income through fees, etc. if there is, for the aforesaid purpose, the Learned Counsel for EPFO is directed to file an affidavit. Affidavit किसका आएगा?
Regional Provident Fund Commission legal.
Of the Regional Provident Fund Commission. The affidavit should also give the breakup of the outstanding amount in terms of the principal amount and the interest amount. वो breakup आप
They have grants in aid, they have taken into consideration grants in aid, and that basis they have calculated. their
on the basis of
grants
grant
in
in
aid. That is why this amount is being accumulated.
पूरा grant in aid
वही
को ले
वही
लिया
हाँ उसके चलते ही वही उसपे खाली अगर इनसे वो separate accounts मान लेता है कि किससे हेड में आप लिए then the matter would be much clearer.
At this, the Learned Counsel for the petitioner has submitted that the EPFO has calculated the entire amount by referring to the grant in aid received by the petitioner from the state government rather than relating it to the actual payment of salary to the teachers. He submits that the actual payment of salary to the teachers is much less as compared to the entire amount received as grant in aid, as the institute by itself has other expenses to be incurred. Ex parte था?
No. Yeah,
Yeah.
they appear. They are filed their
Inquiry report हमने लगाया है रेडिशन उसमें क्या है मुझे हमने वहाँ पे भी ये बोला था inquiry report that you were doing this.
आपके पास कोई डिटेल्स है कि आपने सैलरी कितना
हाँ सर page 145.
The Learned Counsel has referred to page 145
Yes.
of the supplementary affidavit
Which exactly
145.
Is that missing?
145,
essentially
yes, SS3.
financial year admission fee is 3 lakh.
एक्स्ट्रा सैलरी लिखे हैं, ये क्या है?
ये हमको वहाँ से फंड डाइवर्ट कर
नहीं, आप उनको आपके पास कोई ऐसा स्टेटमेंट जिसमें लगाए हैं कि इस पीरियड में आपने सैलरी हेड में कितना पेमेंट किया?
सैलरी हाँ रेडियो देखा जाए पहला कॉलम में देखा जाए सैलरी है 20 लाख 6,000 राइट साइड राइट मार्जिन लास्ट कॉलम.
ये एक्स्ट्रा सैलरी किसको बोलते हैं?
मतलब सेल्स इन टोटल इनकम था 11,45,607. हम सैलरी दिए 20,06,949. ये डिफरेंस अमाउंट का वर्ड थोड़ा उसका वर्ड थोड़ा गलत इस्तेमाल हो गया वहाँ पे उसका सैलरी नहीं लगना चाहिए था डिफरेंस अमाउंट होना चाहिए था डिफरेंस बिटवीन इनकम एंड टोटल एक्सपेंडिचर टोटल सैलरी दैट इज 8,61,340. ये वर्ड थोड़ा सा वहाँ पे कंफ्यूजिंग हो गया. इट शुड नॉट बी एक्स्ट्रा सैलरी.
इन्होंने कौन सा फिगर पकड़ लिया? 20 लाख का फिगर पकड़ लिया है.
वो इसके अलावा ग्रांट इन हैंड जो आया था हमको उसको भी ऐड कर दिया. हमको ब्रेकअप भी देना.
आप इसको समझाइएगा तभी ना जीतिएगा, नहीं तो हार
नहीं
होता है.
उसको आप भी रेडियो का जो क्वेरी है देन आई विल आस्क एंड आई विल आल्सो गिव डिटेल्स व्हाट दे आर कैलकुलेटेड एक्चुअली amount of grants in aid, amount of salary, दोनों को for my calculation दोनों को separate करके the next time.
For financial year 2018-19, there is no mention of the salary detail. Only under the salary they have written EPF. The same as the 2019-20.
Grant in aid बंद हो चुका था.
Salary का नाम नहीं है.
अच्छा एक बात बताइए, ग्रांट इन एड मिला X अमाउंट, इन्होंने सैलरी पेमेंट किया लेस देन एक्स अमाउंट, तो आपका ईपीएफ का कैलकुलेशन तो सैलरी पर होना चाहिए, ठीक है? ग्रांट इन एड पे नहीं होगा. बट इट कैन आल्सो बी पॉसिबल ग्रांट इन एड इज एक्स अमाउंट बट सैलरी पेमेंट इज मोर देन एक्स अमाउंट.
उसमें तो आएगा।
उसमें तो पूरा ही आ जाएगा।
वो हम
ठीक है, I've just recorded that it is his objection. Okay. The affidavit of EPFO be filed by इस साल इस केस का कहानी खत्म करिए, ठीक है ना? हो गया, बहुत चल रहा है by 16th September, post on 18th. ठीक है, आपका इंस्पेक्शन रिपोर्ट कहाँ लगा हुआ दिखाइए?
Order of 7A.
कहाँ है 7A का ऑर्डर?
Annexure 3 of it.
7A का ऑर्डर is also under challenge.
That is on the challenge.
कहाँ है annexure 3 जरा दिखाइए?
Page number 32 of the petition.
32. कैलकुलेशन कहाँ है ये? ई शेयर लिखे हैं। Where is the calculation? ये कोई कैलकुलेशन है? ड्यूज आप सीधे ले आए। ये 7337885 का ब्रेकअप कहाँ है? भाई ये फिगर
It is not there in the order. It is not there in the order.
From where do we find it? इसका ब्रेकअप
Was provided by the enforcement officials of the DPO.
कहाँ है?
No file for them. That will be.
आप फाइल करिए भाई, that is important. How we have calculated the amount.
No file.
ठीक है? During the course of hearing, it also transpired that in the order passed, order contained in annexure 3, which is the order passed under section 7 capital A of Employees Provident Fund and Miscellaneous Provision Act, internal page 3. The dues have been mentioned.
Page number 33. Page number 33.
At running page 34.
It has been mentioned the departmental representative Shri Ashok Kumar Gupta's salary sheets / details of the period April 2018 onwards could not be submitted as salary for this period has not been disbursed. She has also advised, she was advised to submit the Ashok Kumar Gupta is right to verify the enforcement officer Ashok Kumar Gupta से उसका report file, you file the report.
The counsel for EPF is directed to file an affidavit as to how the figures mentioned in running page 34 has been arrived at, to which he submits that the calculation is essentially on the basis of report furnished by the enforcement officer. The report will be placed before this court. ये बोल रहे सैलरी नहीं दिए फिर भी आपका ईपीएफ का डिमांड बन गया। कोई सैलरी नहीं दे तो भी बन जाता है क्या?
What was the report? I am not aware of that.
एक केस हम किए थे जब वकील बिना काम का काम भूल गए। My goodness. हम बता दे रहे हैं अगर सैटिस्फैक्टरी नहीं आएगा तो पूरा रिकॉर्ड मंगा लेंगे हम आपसे, क्योंकि आपको पता है इसमें गड़बड़ी तो होता है।
We will find the details. what they
और
have,
बहुत होगा तो देख सेकेंड, बहुत होगा तो क्या होगा? They will be directed to produce the records as to actual में कितना सैलरी दिए हैं. आपका EPF अमाउंट उतना में ही कैलकुलेट होगा और हो सकता है इनको रिफंड हो जाए पैसा.
65 lakh we already paid.
let's see, we will get all the
रिफंड का
details.
आसार हमको दिखा. चलिए एफिडेविट फाइल करिए आप. ये लुका छिपी नहीं चलेगा मेरे पास. ठीक है, ये हमको बहुत आता है कैसे कैलकुलेट करना. पूरा कैलकुलेशन ईयर वाइज मंथ वाइज पूरा कैलकुलेशन शीट आना चाहिए आपका. पूरा उसका एक्सेल से पूरा डाउनलोड करके और ठीक से उसका एंट्री बना के दे दीजिएगा. आप सर्व करिए भाई, कॉपी नहीं देते हैं.
अब इधर ऑफ द पार्टी नाइदर यूनिवर्सिटी नॉर
क्या तरीका, सरकार से एड लेते हैं.
We have submitted without giving them.
पिटीशन है, पिटीशन की बात नहीं बोल रहे हैं. इधर जो कॉपी फाइल कर रहे हैं कल जो फाइल किए नहीं.
It is directed that every affidavit filed in this case should essentially be served upon the
Served as process conclusion.
upon the other parties.
Without serving, it cannot be filed.
नहीं किसी एक सीधे का फाइल हो जाएगा.
अच्छा हो जाएगा. हम लोग बाहर बात कर लेंगे.
देखिए, it has got a silver lining. इसका कुछ रिजॉल्व हो जाएगा, हम समझ लें. खाली आप हमको बताइए कि कैसे कैलकुलेट किए. ग्रांटेड रेट का फिगर लेके कैलकुलेट कर देंगे क्या? कर सकते हैं क्या?
नहीं होगा. हम
देखिए, आपको एक चीज बता दे रहे हैं, सैलरी वाकई में टीचर्स को नहीं मिल रहा. ऐसा इंस्टीट्यूट में ऐसा होता है, टीचर्स का सैलरी का नंबर सबसे लास्ट में आता है. You should produce.
That is being mentioned in the improved order. I'm completed one line only. Sri Ashok Kumar Gupta submitted his deposition report on such and such date. This was taken on record. He worked out EF and allied dues for the period so and so on the basis of salary register, sheets, and audited books of account, including books of account for grant in aid.
आप प्रोड्यूस करेंगे और आप इलेक्शन में.
अभी इलेक्शन का माहौल है. अभी तो इलेक्शन का माहौल है.
5 लोग मिल जाता हूँ धीरे से पहले वोट दे दी.
5 लोग के अपोज करके वोट नहीं देंगे तो
आप लोग सब लड़ रहे हैं क्या इलेक्शन?
भैया लड़ रहे हैं, हम लोग हैं भैया के साथ.
आज तक कोई बोला है कि हम आपके साथ नहीं
नहीं
हैं?
है भाई साहब फ्रेंडली है.
Orders notified item 4, first topic file number 4691 of 2025.
There is a press stamp reporting from 17th and
क्या है इसमें?
ये again the reference not under section 30. This order has been passed, and thereafter not I have filed this appeal under section 54 of the Land Acquisition Act 1980. Not now an objection has been raised with respect to maintainability.
Saying what?
That not this appeal should have been under section 96, and since the award which is under challenge, it is with respect to 1,45,000, then this particular matter should be remitted back to the civil court.
तो अंडर सेक्शन 54 तो कहाँ पे फाइल होता है? हाई कोर्ट में.
High Court में file होता है 54 High Court में. There are 2 judgments which have also been mentioned in the note.
आप उसको एग्जामिन करिए.
हाँ, एक बार एग्जामिन
होगा, आपको आइए फाइल करना पड़ेगा.
हाँ,
ऐसे
हाँ,
नहीं
हाँ.
करेंगे. राइट. दिखाइए जरा लैंड एक्विजिशन. सिर्फ हाई कोर्ट ही लेगा.
हाँ, इसमें हाई कोर्ट की But Lord, there are two judgments which have been noted, Lord. Though I have not examined those judgments, Lord. But
One is 1988 PLDR
yes, Lord, I
674.
have written.
Okay. The learned counsel for the appellant prays for time to file appropriate petition in connection with the objection regarding maintainability raised by the office. कब रखते हैं बताइए?
But after 3 weeks, I need
Post on 2nd of September. Post on 9th of September. In supplementary context.
Item 5.
the same.
Same offer. होगा ये हाई कोर्ट में ऐसा लग रहा है. Let us
Item 6, first appeal 387 of 2026.
Three matters, 6, 7, 8, same issue.
what is it?
In this case as well.
6, 7, 8 क्या
Six.
इशू है?
इसमें
ऑर्डर्स में लगा हुआ है.
वही लगा हुआ है कि सेक्शन 30 का जो है तो हमारा जो है वो वैल्यूएशन कम एंड दिस मैटर इज टू
वैल्यूएशन का what is the objection?
ऑब्जेक्शन दे हैव पुट मेंटेनेबिलिटी पे कुछ नहीं
मेंटेनेबिलिटी पे तो कुछ नहीं है.
नहीं दो बार स्टाम्प रिपोर्टिंग हुआ कुछ नहीं था. अब थर्ड टाइम इन्होंने स्टाम्प रिपोर्टिंग करा.
क्या किया? क्या स्टैंड रिपोर्टिंग में करते हैं?
जस्ट कि ये 106 का है, वैल्यूएशन कम है, ये डिस्ट्रिक्ट जज के यहाँ फाइल. हम सेक्शन 54 में पहले फाइल किए, फिर इन्होंने ये लगाया कि भाई ये 196 में फाइल है, तो मैं पे इसको भी रख दिया जाए 9 सितंबर.
अब इसको जो करना है करिए.
ये 3 जजमेंट पे जो है जो इन्होंने कुछ ये किया, ये 3 चीज
छोटा छोटा चीज के लिए कोई भी चीज क्यों? आपने ये फाइल किया है इसमें?
जी अभी कर देंगे. आज ही पता लगा. पहले कि इसमें केस नंबर भी पड़ गया, इसके बाद इन्होंने पॉइंट आउट किया. Section 30 जिसमें in this particular case section 18 as well as section 30 both are in issue.
तो ये तो इतना सारा ऑर्डर है ट्रांसमिट कर दिया वहीं पर.
हाँ वहाँ पे किया इसका तो
ये तो सेम ऑर्डर इसमें इनके भी होना चाहिए.
हाँ इसमें भी उससे पहले वाला भी लगाया.
तो फिर
इसमें लगाया
आपने यहाँ
फ्लैग
फाइल
एक्ट में
किया,
लगाया.
आपका पिक्यूनरी जुरिसडिक्शन कौन सा है?
पिक्यूनरी जुरिसडिक्शन वो 25 लाख से बिलो. केवल एक इसमें इन्वॉल्व है कि सेक्शन 18 में यदि हम फाइल करते हैं अंडर द लैंड एक्विजिशन एक्ट तो अपील जो फाइल होगा वो अंडर सेक्शन 54 ऑफ द लैंड एक्विजिशन एक्ट होगा. यदि सेक्शन 30 में होगा तो ये 96 में होगा. मेरे इशू में सेक्शन 18 एंड 30 बोथ आर इन इशू. इसमें जो रेफरेंस हुआ है दोनों में
seeking enhancement also
हम
and you are seeking dispute also. There is a dispute with apportionment also.
there were two parties. तो इसमें हमारे तरफ से तो 30 का पिटीशन गया था, दूसरे के तरफ से 18 का गया. तो 18 एंड 13 बोथ में डिफरेंस है. क्योंकि लगा हुआ है तो एक टाइम दे दिया तो 9 को दे दिया. 9 को ही कर दिया. नहीं होगा तो पिटीशन फाइल
for the appellant submits that the matter be posted on 9th in the supplementary cause list and in the meantime we shall file an appropriate petition in connection with the office objection. ये जितने भी है ना ये सब जजमेंट्स दे दीजिए. 1988 PLDR 674 इसमें रख देंगे. एक 2002 वॉल्यूम 1 GLDR 620 इसको भी इसमें रख देंगे और ये वाला ऑर्डर 18/7/2019 का तो ऑर्डर में रखिए, ठीक है। During the course of hearing, it transpired that the order, the judgment passed by judgment reported in 1988 PNGS 674 and judgment reported in 2002 within bracket 1 JNJR 620 and order passed in FA number 118 of 2011 dated 18/7/2019 on the point of pecuniary jurisdiction would be relevant for considering the office objection. So, इसको यही छोड़ दें। आपने 3 केसेस
6, 7
सब सप्लीमेंट्री
6, 7, 8 सप्लीमेंट्री उसी रहेगा। Order Saturn 9 CMP 1024 of 1026.
तो एप्लीकेशन के लिए था मुझे उससे पूछा गया था प्रभात खबर औरंगाबाद में छपता है कि गया में छपता है और उसका एडिशन जाता है औरंगाबाद में। तो प्रभात खबर गया औरंगाबाद एडिशन, एक रांची में छपेगा, एक औरंगाबाद गया में छपेगा।
Heard the learned counsel pleading on behalf of the petitioner. He has referred to the order dated 14/8/2026 and has submitted that IE number 9927 of 26 has been filed for substituted service of notice upon opposite party number 5, 6 and 7, who have 2 addresses, one at Ranchi and other as at Aurangabad, Bihar. He submits that Prabhat Khabar Ranchi has, and then Prabhat Khabar has circulation in Ranchi, in Ranchi edition, and also has circulation in Aurangabad, in Gaya edition.
No, published in Gaya, Prabhat Khabar Ranchi
Has
in Aurangabad
is also
edition.
published in Gaya and
Aurangabad.
has Aurangabad edition.
Edition.
Considering the aforesaid submission, the petition for substituted service of notice upon opposite party number 5, 6 and 7 is allowed. The counsel for the applicant petitioner is directed to furnish format for draft notice for publication in Prabhat Khabar Ranchi edition and Prabhat Khabar Aurangabad edition. Aurangabad edition in Bihar. Within a period of 1 week, the office is directed to verify the draft notice to be published and hand it over to the learned counsel for the petitioner so that the same may be published in the aforesaid newspapers. Office is directed to place this case on 14th of October. The supplementary affidavit annexing the newspapers be filed by 30th of September. I will know.
Item 10, First Appeal 366 of 2026.
What is the head?
Defect no limitation for petition of order First Appeal.
Limitation पे notice कितना है limitation? आपका केस कॉल आउट हो गया है।
Item 10.
88 days.
88 days.
Notice
FA number 366 of 2026 with IA number 7103 of 2026. Let notice be issued to the sole respondent in the first appeal as well as in the interlocutory application. The question of taking up the matter in first appeal would arise only if ultimately interlocutory application seeking condonation of delay is allowed, which is only to the extent of 88 days. In the meantime, let the records be called for from the concerned court. Communicate. Requisites होगा किसमें? Speed post. Requisites will file within a period of 1 week. Through speed post, office is directed to track speed post delivery and prepare appropriate office note with regard to service of notice. इसका कोई execution pending है?
डिस्कशन होगा भी नहीं, डिक्लेरेटरी रिलीफ है।
Close this case on 16th of September. ये एडमिट नहीं कर सकते हैं, we delay कंडोन नहीं हुआ, दोनों में नोटिस करेंगे।
Item 11, first appeal 3.88 of 2026.
Delay of 162 days. Item number 11375 of 2026. Confirmation of the delay of 162 days.
What is the suit for?
Notice.
Sale deed, challenging the sale deed.
Two sale deeds have been declared null and void in authority and not binding upon the debt.
Let notice be issued in first appeal number 388 of 2026 and also in IA number 11375 of 2026 to the respondents for which requisites to speed post as well as ordinary process be filed within a week. The question of hearing the first appeal on merits.
Both parties.
2 weeks. The question of hearing the first appeal on merits would arise only if the delay in filing the appeal, which is to the extent of 162 days, is ultimately condoned. Let the records be called for from the concerned court. Close this case on 30th of September. Awaiting service.
For admission, item 12, first appeal 379 of 2026.
This appeal has to be admitted. It is listed for the first.
Call for records from the concerned court. State of Jharkhand hai. The state of Jharkhand is already represented by learned counsel, so no notice need be issued to the state of Jharkhand. Let notice be issued to the respondent number 1 and 2 to speed post and ordinary process for which requisites be filed within a period of 1 week from today. Close this case on 30th of September, awaiting service report. In the meantime, let records be called for from the concerned court. Record आ जाएगा जब पार्टी appear होगा, तब आप तैयार हो जाइए. Delay कितना है? 160. There is no delay.
There's no case is registered.
Item 13, first appeal 386 of
It is under the
2026.
heading of admission.
Admit the party. Yes. Yes, appellant.
It is paying for shop password.
It is for admission.
Yes, ma'am.
Up on previous time.
Respondent number 1. The plaintiff filed partition suit claiming 1/3 share which was dismissed, against which this appeal has been filed. And the respondent number 1 was.
भागीरथी मंडल
Yes.
और बाकी लोग कौन है? आप ही का
बाकी
परिवार
के
वाले?
लिए लॉर्डशिप नोटिस है, हमको तो एक ही का वकालत मिला।
ऐसा तो नहीं हो सकता।
नहीं, हमको तो एक ही का मिला है लॉर्डशिप।
मिला सबका फाइल एक करके।
नहीं नहीं, ऐसा तो हुई नहीं,
ऐसा
जो जानते
नहीं?
हैं हम लोग बारे में जानते हैं नहीं, मिलता तो सबको फाइल कर
Admit.
देते हैं।
Respondent number 1 has already appeared by filing wakalatnama, so no notice be issued upon respondent number 1. Let notice be issued upon respondent number 2 to 4, for which requisites under ordinary process as well as speed post be filed within a period of 1 week. Poses case on 30th of September 2026, awaiting service report. Let the records be called for from the concerned.
Appellant may be directed to serve the copy of the memo of appeal.
It will serve.
Item 14, first appeal 393 of 2026.
Yes, appellant. ये भी admission के लिए है। Admit. Appellant absent. Admit. Let notice be issued upon the respondents through speed post and ordinary process, for which requisites be filed within a period of 1 week. Let the records be called for from the concerned court. Since the counsel for the appellant is absent, let a copy of this order be forwarded, a soft copy of the order be forwarded to the counsel for the appellant to ensure compliance. ये क्या है? तो इसका नंबर नहीं लिख रहा हूँ इसमें। FA नंबर
393.
इसके ऊपर लिखा हुआ है। चलिए इसको
May I mention one case law? In serial number 7 in Delhi, it is an order with different. It may be listed tomorrow.
Daily and following.
Serial 7.
Just we daily वाला list कौन सी हुआ? There are so many matters which are listed.
Daily order with effect 4 to 7.
4 to 7. ठीक है, देखते हैं just a moment. 4 नंबर का मतलब आइए एक और लिख दो और बाकी सब केसेस में you are for serial number 7.
7.
It will come up in the next week. Is there any urgency?
Yes, the respondent has filed execution notice.
Execution. You have filed one petition for ignoring the defect.
Yes.
What is that defect you want?
One with regard to court fee, which I have already filed as per the court fee act, and two with regard to
You have
filing
already filed as per court fee act. How much court fees have you filed? 1,000 fixed court fees.
Yes.
There is no consequential relief. We are only seeking declaratory relief.
Lord's sake, as per the latest amendment, points or memorandum of appeal in such of the following suits, इसमें है column 4 में to set aside an award. इसमें जो है अवार्ड
आपने
है
आईए फाइल किया है ना
Yes.
इसके लिए अवार्ड है इसमें
यस रेफरेंस के अगेंस्ट है अवार्ड ऑफ रेफरेंस। दो और डिफेक्ट है उसमें था कि हमको अवार्ड फाइल करना था रेफरेंस कोड का, तो जिसमें मैंने सर्टिफाइड कॉपी के लिए अप्लाई किया, वहां से रिमार्क आया कि देयर इज नो सेपरेट अवार्ड हैज बीन प्रिपेयर्ड। आई हैव annexed in my IE।
इसको नेक्स्ट डे को टेक अप करेंगे। अभी लेटेस्ट एक जजमेंट आया है सुप्रीम कोर्ट का लैंड एक्विजिशन मैटर्स में रिलेटिंग टू पेमेंट ऑफ फीस, उसको थोड़ा देखिए। आपका कौन सा ऑर्डर आप लाइक करते हैं? इज देयर
I am
एनी
relying on the latest amendment of
That's
fee Jharkhand।
इस पर हम कुछ एक ऑर्डर भी किए हैं जो सुप्रीम कोर्ट का पेंडिंग है। आई रिमेम्बर इसमें एक ऑर्डर हमने किया है, इस चेन्नई मद्रास हाई कोर्ट का कोई जजमेंट मिला क्या?
एक तो मिला है जिसमें एड वैलोरम कहता है, मगर आई एम रिलाइंग ऑन
मैंने
लॉ।
होल्ड किया है कि इसमें एड वैलोरम देना है, उस ऑर्डर के अगेंस्ट में मैटर सुप्रीम कोर्ट में पेंडिंग है। लेकिन एक सब्सिक्वेंट ऑर्डर अभी जजमेंट आया है सुप्रीम कोर्ट का कि एड वैलोरम देना है, लेकिन वो उस केस में नहीं डिसाइड हुआ है, तो आई डू नॉट नो।
द रिलेवेंट
उसमें काउंसिल अपियर कर रहे थे, बता दे रहे हैं ना कौन कौन काउंसिल, उनसे पूछिएगा तो बता देंगे। मिस्टर अजीत कुमार सीनियर एडवोकेट वाज अपीयरिंग विद मिस्टर महता, क्या नाम है उनका, देखिए शर्मा जी को पता है। आपका भी हम किए हैं ना एड वैलोरम नोटिस। हाँ, that is a separate thing. That is a separate thing. In land acquisition matter, whether ad valorem, वो मिस्टर अजीत कुमार सीनियर एडवोकेट, अभी वो इलेक्शन में बिजी होंगे, लेकिन उनसे मांगिएगा तो दे देंगे।
ऐसे हम रिलाई कर रहे हैं।
नहीं, जब हम एक ऑर्डर कर दिए तो हम कॉन्ट्ररी ऑर्डर तो नहीं करेंगे, इसीलिए आपको बोल रहे हैं। वो ऑर्डर आप लेके आइए, हम वो ऑर्डर किए हैं, वो अपियर होते थे उसमें, वो लंबे लंबे से हैं। हाँ शायद, हाँ हाँ वही वही अपियर हुए थे, वही अपियर। हाँ हाँ, नीलधारी मुखर्जी बन सकती है, आप पता करिए, ठीक है। इसको नेक्स्ट वीक रखते हैं, वो ऑर्डर लेके आइए, then we will see what is to be done। आइए फाइल किए हैं फॉर इग्नोरेंस, इसको रख सकते हैं, नेक्स्ट वीक आएगा। हाँ बताइए आपको क्या
आइटम नंबर 4 में हमारा अपीयरेंस
अपीयरेंस ऐसे नहीं रिकॉर्ड होता है, यहाँ पर जो अपीयर होते हैं उसी का अपीयरेंस रिकॉर्ड होता है।
एपोलॉजी मैटर में
कोई बात नहीं, क्या होगा
इसमें
इसमें तो हम एडमिट कर दिए।
इसमें नंबर पढ़ने के लिए तो कर दिया था।
कौन सा?
ये 4 नंबर।
4 नंबर कौन सा?
4 सीरियल डिफेक्ट।
इसमें क्या क्या
इसमें अगर साइड में टाइम दिया था तो फाइल लिखना है, तो लिखना ही मैंने फाइल भी कर दिया।
अच्छा, ये तो केस फॉलो आउट ही नहीं हुआ है।
नहीं, इसी टाइम मांगो।
स्लो है चलता है, इतना स्पीड आप लोग की तरह नहीं है।
7 दिखा रहे हैं
वो क्योंकि वो थे इसीलिए 7 मिनट, ठीक है। अगला दिन आपने रिप्लाई नहीं फाइल किया इसका?
नहीं, इनका मेरा प्राइवेट रिस्पोंडेंट है, उनको कहा गया तो फाइल नहीं किया।
अब उसका आप रिप्लाई नहीं देखेंगे, सीधे आइए अगला हफ्ता,
कम से कम नंबर तो
अगला हफ्ता